Please, Lordship. My response submission is that maybe this PIL can be disposed of at its stage itself. Because because of the infamous paper leakage issue, that issue has two aspects. One is the criminal part, totally criminal part. Another one is the financial aspects. The criminal part, SIC vigilance case number 11 and 12 has been registered, and this is being taken off by the CBI. And in that situations, it appears that there was huge monetary transactions, and that aspect is not being taken care of by the criminal case, madam. So therefore, madam, my resolution submission is that the response number 1 to 5, the Director of Enforcement cannot decide to and not to investigate. And secondly, the response number 6 and 7, the state respondents and the Public Service Commission, they cannot decide not to and not being referred to the Directorate of Enforcement.
Response number 6 and 7?
Six is state, 7 is Public Service Commission. My response submission is that money trail has to be also investigated, and in that process, if it entails any criminal liability, that is another aspect. But otherwise, Malad, there is
Nothing, sir, right? What is your prayer?
get it only investigated by the director.
Only two fall, my lord. One is by CBI, one is ED, my lord.
ED has already
Yes.
reported the case and the investigation is
Going on.
No, our specific stand is that this paper leakage issue by case number 11 and 12 is being taken off only on the purely on the criminal aspects of as to why there was a paper leakage.
Yeah, criminal aspect, yes.
That has been taken by the CBI. ED has also recorded the cases.
Earlier, SIC Vij was taking.
Yes,
earlier,
my lord.
And
Yes.
thereafter CBI took over.
That has been transferred to CBI, my lord. That is in criminal matter. So the financial matter is concerned, ED has taken the cognizance, man. That's all.
I don't think Malad, ED has taken up the matter.
Do you
No, no,
have
no.
the records, all the records. do you have?
No, I have only the petition copy. Yeah.
First, they have already said we have initiated. And this court wants to know what initiation. Then they have filed a second affidavit.
Yes.
Look,
Nothing, sir, right?
but that copy has not been furnished to me. Only this writ petition PIL copy has been.
You from the page 21. What is your prayer?
Yes, Enforcement Directorate.
Yeah,
That especially the money trail.
yes. ABL is basically for that.
Malad, I have not been furnished with a copy of.
There's nothing.
Nothing, sir.
In that case, Malad, let it be fixed tomorrow. Let me go through. I have this was not furnished to me. It was furnished to me only on 10th.
Yes. What the affidavit?
You do not have the copies?
No,
That might have been my other.
I was appointed as amicus curiae.
No, that was given to the petitioner because he appointed person. That was given to him.
Let it come up tomorrow, Mel.
It's possible for the time so that my in-law can go through.
Go through it.
This can be.
I do not think it's a very voluminous document.
It's small affidavit.
We have only 2 matters, no?
Another is this different aspect.
Okay.
Let it be come up tomorrow, Mala. Let me go through this.
Tomorrow. Yeah. All right. Tomorrow.
Yeah.
I have time constraint tomorrow, actually. This is why I'm so hesitant.
But otherwise,
Yeah.
It's only for closing. the
All right,
prayer.
all right, tomorrow.
Go through the affidavit.
yes, I haven't gone through that.
Tomorrow? You give me a hand with this.
Yes, yes.
I'll do it. I'll-
Like,
As agreed by the learned counsel for both the parties, list the matter on tomorrow, what is the date? 13, 14.
Your Lordship, as per the office note, the unserved notice was received, Your Lordship. Now we need to verify the address of the respondent number 2, Your Lordship, because she was not found there in the address provided in
She
the,
was not found in the address.
yes, Your Lordship. So we have to verify the address from the record, Your Lordship. Perhaps she is not the permanent resident of that locality.
It's like,
Yes, Your Lordship. It's there in the, reflected in the office note.
learned counsel, Miss A. Apang is learned senior advocate, Miss.
Lordship,
Senior
I'm
advocate?
appearing on behalf
Okay,
of Mr.
okay.
Yap
Yes, you have a good name?
and Anju.
Learned Miss N. Anju is present on behalf of learned senior counsel, Mr. E. Apang. Learned additional PP, Mr. T. Ete has submitted that the address of the respondent number 2 has to be verified. The office note dated 7/5/24. No, not 7/5/24.
1710.
17/10/23. Okay. The office note dated 17/10/2023 indicates that respondent number 3,
3 years, Your Lordship.
that instead of respondent number 2, you write down respondent number 3. Office note dated so and so indicates that the respondent number 3 has left the address. The address may be verified. List the matter on when you want.
After, Your Lordship, 4 weeks, we will verify and steps has to be taken.
Address of respondent number 3 may be verified. List the matter after 4 weeks.
Okay, Your Lordship.
Obliged.
Deeply obliged.
Well, they,
Your Lordship, the concerned additional PP who was conducting the case is not in the station. So this matter will state after a week, Your Lordship.
Hmm.
no, it's,
Why these cases are fixed for, listed for adjournment?
not, I can't express anything on this because the council must have some personal difficulties. And then Lordship has,
Cases are listed for adjournment.
Lordship, I don't know because Lordship also once been an advocate must know the problems of the council.
It is listed, it is for adjournment.
No, candidly, it is not.
After a week,
After a week, Your Lordship.
learned counsel, Mr. T. Tara is present on behalf of the petitioner, appellate, comma, and learned additional PP, Mr. T. Ete is present. The learned additional PP has submitted for a week's time as the learned counsel, learned additional PP dealing with the present case is indisposed today.
Yes, Your Lordship.
List the
Deeply
matter after 1 week.
Deeply
Okay.
obliged, Your Lordship.
Yes, Lordship, today that we are filing rejoinder, Lordship.
What is the ground? After
Let's-
you challenge this,
Yes,
the
Lordship, this,
enactment,
yes, Lordship, this is,
what are the ground for challenging the enactment? Enactment.
exactly, Lordship, this act is against the basic,
Here are only 2 counts. Now the scope has been enlarged.
Lordship, only,
Sarah Banu's case.
Lord-
Unless we can show this 3 grounds,
yes, Lordship, that I will,
including the enlarged and where the scope has been enlarged. Nothing.
Lordship,
This should be,
this-
How can you done like this?
Lordship, that's why today I am filing this rejoinder, Lordship.
You cannot improve your case by filing a rejoinder.
Lordship, that act is against the basic structure of the constitution. Not only basic structure of the constitution, but against the spirit of.
It's a very interesting point.
Yeah, exactly, Lordship.
The state has enacted a law against the basic structure of the constitution.
That's
Please
it.
show us. We are hearing you.
Lordship,
Yes,
We are
can be
hearing-
heard.
Lordship, that without filing this rejoinder, I would not able to satisfy this honorable court, Lordship.
It is litigation.
Exactly, Lordship.
Are you ready? They're ready, so you can submit.
Lordship, at least,
You show us three things only.
Lordship.
One is if there is any lack of legislative competence.
Lordship.
Number one. Number two, if it violates the fundamental or constitutional right of the citizen.
Lordship.
Number three, manifest arbitrariness.
Lordship.
Only three grounds.
Lordship, this main ground is repugnancy, Lordship. Lordship.
Make a-
Lordship, that
make a- And then read the Kutuswami. And
Lordship.
then the Sarabhan. What is Sarabhan?
Lordship, that basically that it against.
Sarabhan, what the scope of has been enlarged. Have you read?
Lordship, that I have go through the Kesananda Bharti case and Minerva case, Lordship. That against the spirit of the basic structure.
PI, there's nothing, it's a sweeping decision.
Lordship, maybe fix on tomorrow, Lordship. Today I will file.
No,
this
not tomorrow.
with that.
Not possible tomorrow.
Are you saying, state, the legislative, has no, competence?
Now, Lordship, that on that ground, that the subject comes under the concurrent list, this has to be given assent by the President of India, Lordship. Even Assam Preventive Act and Gujarat Anti-Preventive Act, they have sought the assent of the this President of India because it,
Hearing,
Lordship, kindly matter may be tomorrow, Lordship, because
Maybe day after tomorrow, not tomorrow.
Lordship, that may be, Lordship.
If it is not today, my lord, it can either be because I'm coming back again on
I know,
Friday,
I know.
either Friday, my lord, or on 3rd of June.
Either Friday or 3rd of June. You are praying for adjournment.
Lordship, that any day after this today, Lordship.
Learned counsel for the petitioner has submitted that he has filed a rejoinder today.
Lordship.
I don't think he has filed because we have not been given a copy.
Exactly, matlab filing, Lordship.
Copies of the rejoinder to be furnished to the learned government advocate. I forgot your name.
I am Aisha.
Mr. I. Chaudhary. Government, learned Advocate General Arunachal Pradesh, Mr. I. Chaudhary. And Ms. P. Pangu,
She is assisting.
assisted by Ms. P. Pangu. List the matter on, when do you want? On Friday?
4th of June, my lord. if it is
4th
not.
of June. List the matter on 4th of June.
I am available on Friday also. I'll leave it to your lord. Either-
Friday?
Lordship, I am ready, Lordship.
Friday? Friday, I am not certain, but if somebody will.
In that case, let it-
DB, I'm not.
Let it be on 4th. 4th of June.
Fourth, yes.
You read those judgments
I would like to.
and improve your case.
Red petition, Lordship, this is regarding the eviction, Lordship. It's a very short matter. It will take only 2 minutes, Lordship. Can it be taken up today, Lordship? After the, it's already being filed, Lordship.
If possible, yes.
Lots.
Very short matter if you are saying so.
Lordship. Deeply obliged.
You have the filing number.
No, Lordship, it's in the process,
Just-
Lordship.
Oh,
It will become before your Lordship. Deeply obliged.
Lordship, with the consent from our side, I beg to mention item number 6 and 7. This matter may be fixed after 3 weeks.
Lordship, item number 7. There is a connected matter. Only the matter may be list together.
together, okay.
Yes.
Item number 6,
No.
Learned Counsel, Mr. T. Tagum,
No, Arkoyu on behalf of Titagum.
R. Koi.
Arkoyu.
On behalf of learned counsel, Mr. T. Tagum has, with the consent of the other side, has prayed for adjournment. List the matter after 3 weeks. Again, in item number 7, learned counsel, Mr. R. Koi, on behalf of learned counsel, Mr. T. Tagum, for the respondent, with the consent of the learned counsel for the petitioner. Petitioner
Petitioner.
has prayed for adjournment. The learned counsel for the petitioner, Miss
D Rilo.
D.
Rilo.
Lilu,
Dusurilo.
has submitted that the matter may be listed along with along with WPC number. WPC numbers 618, 619, and 617 of 2022. List accordingly after 3 weeks.
Much obliged.
May I beg to mention, a few days ago, matter was listed one WP, but the interim order could not be continued. This matter was appeared by Mr. Monojit Biswas, a Guwahati-based lawyer. But he was absent and nobody appeared in the case. So matter may be listed on 15th, day after tomorrow. He will come.
Lordship, I would like to mention item number 17 to 20 on behalf of Estapin, Your Lordship. He is for the contemner or for all the 20 for the respondents on behalf of Estapin.
On behalf of
Estapin, Subutapin.
learned
I appear for petition,
Ah.
taken up after 1 week.
after 1 week,
Yeah.
okay. Learned counsel, Miss R. Basar.
Lordship,
For learned counsel, Mr. Subutapi, appearing for the respondent with the consent of the other side, learned counsel, Mr.
K Tapi.
K.
Tapi. Karyam Tapi.
Dabi
Yes.
for the petitioner, has prayed for adjournment. List the matter after 1 week.
1 week, Lordship. Again, Lordship, item number 21, Your Lordship. This also on behalf of Estapin, Your Lordship. He is the standing counsel for APSSB, Lordship. Lordship, this matter may be taken up on tomorrow, Your Lordship, on 14th.
Miss R. Basar for the learned counsel for the petitioner, Mr. S. Tapin, has, with the consent of the other side.
Yes, Your Lordship.
Has prayed for adjournment. List the
Tomorrow.
matter
Tomorrow, Lordship.
not definitely not,
Lordship, after tomorrow.
or day, or even one more day after. All right, list the matter on tomorrow. What is the date? Day after tomorrow, 15th.
15th of July.
Please, Your Lordship. Lordship, I beg to mention item number 23. Lordship, I am for the petitioner and I have taken consent from opposite parties. So kindly this matter may be fixed on 20, Lordship.
20.
Yes, Lordship.
Learned counsel, Mr.
D. Lona.
D.
D. Lona.
On behalf of learned counsel, Mr. D. Panging,
Yes, Lordship.
with the consent of the other side, has prayed for adjournment. List the matter on 20th,
20. 20.
20,
20.
2002 or the 2005.
Yes. Obliged, Lordship.
May I, Your Lordship?
Hmm.
Your Lordship, I beg to mention item number 13
Hmm.
on behalf of J. Gini, Your Lordship. Matter may be listed after 2 weeks. Your
Learned
Lordship.
counsel, Mr. So-and-so, on
He mentioned.
behalf of learned counsel, Mr. J. Jenny, with the consent of the other side, has prayed for adjournment. List the matter. When do you want?
2 weeks. 2 weeks,
2
Your Lordship.
weeks.
13.
Yes,
After 2 weeks, Your Lordship.
after 2 weeks.
Much of this.
Hello, I would to mention item number 10.
Hmm.
Can it be listed on 21st month of this month?
Learned counsel, Mr. R.L. Tungon.
Yes,
On behalf of the other, or with the consent of the other side, has prayed for adjournment. List the matter of
21st month.
21st May.
Obliged.
May Your Lordship, I beg to mention item number 11.
Hmm.
Matter may be adjourned for today. Here we have to file rejoinder, so we'll be filing, so matter may be adjourned.
You'll file rejoinder.
No, yes, we will be filing rejoinder.
Rejoinder. Learned
Yes.
counsel, Miss So-and-so, on behalf of learned counsel for the petitioner,
And Pada,
and Pada, with the consent of the other side, has prayed for adjournment. The learned counsel for the petitioner submitted the day will be filing
Rejoin.
rejoined.
Yes, your lordship.
List the matter when do you want?
3 weeks.
List the matter after 3 weeks.
Yes.
What is-
Yeah, your lordship.
Mm.
Lordship, item number 3, this matter was supposed to be listed after 2 weeks.
Mm.
This was last listed on 7th of this month, your lordship. This has wrongly come up today's list. So may I pray that this matter may be listed after 2 weeks, your lordship?
Learned Counsel Ms. N. Anju, with the consent of the other side, has prayed for adjournment. List the matter after 2 weeks.
Lordship, obliged.
May I, my lord?
Mm.
I have filed one IA in this petition, my lord, for impleading respondent number 10, 11, and 12, my lord. For impleading the JOC, my lord, General Officer in Command, page 10, my lord, of my IA, my lord.
Page, yes.
10, down below, my lord. 10, the General Officer in Command, my lord. Next page, my lord, 11, 5 Mountain Brigade, so and so. And 11, the Commander, 190 Mountain Brigade, my lord. 12, the Administrative Commander, 190 Mountain Brigade, my lord. As respondent number 10, 11, and 12, my lord. Because they are the, my lord, station head of the Indian Army, my lord, which are posted in, my lord, Tawang. So they are necessary party, my lord. So I may be allowed to, my lord, implead them as a respondent 10, 11, 12, and I may be directed to amend the course title, my lord.
We don't have any objection because the as per the information received from the concerned department, they are the responsible for this piece of bill. So therefore, in fact, we supposed to file an implement petition before the IA, but that has not been taken place now. So this may be allowed with the we'll file our affidavit.
In that main case, you will file the affidavit.
Fine. For implement, we
Have no objection. Learned Counsel Mr. B. Pacha
Yes, picture.
is present on behalf of the applicant who has filed this application. With prayer to implead the General Officer in Command, hyphen, 5 Mountain Brigade Division, Indian Army, then you write in paragraph mode. Number 1, this is 1 paragraph. Then number 2, Commander 190 Mountain Brigade, Indian Army. And then third one, the Administrative Commander 190 Mountain Brigade, Indian Army. Then last paragraph, all under CO, care of 99 APO Station Headquarters, Tawang, Arunachal Pradesh. It is submitted that they are necessary parties as the station head would be able to represent the Indian Army who are in possession of the community land of their applicants located at Nagula, Y-junction, Klemta, Khamakher, Assam Hill, Bakri Top, and Bumla area of Town Division. Stop. Part Mr. M. Kato, learned DSGI, Mr. D. Kamduk, learned GA, AP.
I am standing counsel.
Oh, Standing Council Land, Standing Council Land Management, and Mr. sorry,
Iram,
I Ingram,
number 9,
I Ingram, on behalf of
Deputy Commissioner.
Deputy Commissioner. Learned GA, you write on Learned GA, not on behalf of a Deputy Commissioner, Learned GA AP. The Learned Counsel for the respondents has no objection. Considering the submissions at the bar, the application is allowed prior to implead. The general officer in command, the commander and the administrative commander, as respondent number, how many? 11, 10,
10,
10,
11 and 12.
12 is
10.
hereby allowed.
My lord. I may be directed to, my lord,
The petitioner to file that an amended cost title.
comment and question. Obliged, much.
Then in this case,
The main case may be fixed after 3 weeks. madam.
Yes.
Maybe that will come in.
release this matter after 3 weeks. Main case mein, huh?
Obliged.
Mm.
To my lord, I have to file my rejoinder, my lord. I may be given, my lord, 4 weeks time, my lord.
Learned Counsel Mr. B. Pincha, with the consent of the other side, has prayed for time to file rejoinder affidavits.
Hello.
This is the matter after 3 weeks. No,
Hello.
2 weeks, Naki, list accordingly. What was the time he was asking for? 2 weeks. That in the sentence you have mentioned? No, you have mentioned. List the matter after 2 weeks.
My lord.
2 weeks,
3 weeks. my lord.
3 weeks.
Obliged. Or interim may be considered. Interim order may be considered.
Interim order shall remain in force till then.
Next step. Obliged.
My lord, I have raised the question of maintainability, and today is to hear it on the maintainability. Because this case has become infructuous. Not in this case, main writ petition is directed against the recalling and cancellation of the LPC. And for any issue that is regarding the land matters, it is the civil court will decide. And in any case, basing on this recalling and cancellation of the LPC, a Gabang was held under the AP Civil Courts Act, and that customary court has decided its title also. And in the meantime, petitioner has filed an IA in this writ petition, assailing the customary court decision. And this honorable court felt that no, this is not the forum. You may go to the lower forum, appropriate forum, if so advised. Accordingly, they have filed a title suit being 05 of 23 before the
District judge.
but before the civil judge,
Senior division.
senior division, and it is pending, Malad. So in view of that, Malad, let the entire matter is to be decided by the civil code only. So since the matter is pending in the civil court, there is no point keeping this as pending, because pendency of the court case in the High Court, in somehow it may affect the thinking of the lower court. Yes,
Civil court
yes.
to decide the matter in.
Yeah, let them decide whether the decision on the title is correct or not.
Yes.
Well, let the affidavit come, because the state government, they wanted to file the state affidavit.
Otherwise, there is no point.
Well, let the affidavit come. At least, of course, on merit, it will be decided
After the affidavit.
after the affidavit. We have our own case, projected case, right or wrong, this way or that way. The LPC has been cancelled, not following the due process of law, That is the whole thing, And yes, after cancellation, of the SPC, 2 LPCs, the village authority, now the customary court has
Yes.
decided in favor of them, Then against that, we prepared an appeal. Admittedly, that is pending, That is one aspect, regarding the decision,
This is
rights and
the civil-
titles over the disputed land, Now here the only initially the LPC was issued that because of the cancellations of the two LPCs, my lord, the title suit has been decided. So therefore, my lord, this is the root, this is the my lord, main things, my lord, which has to be adjudicated first, my lord. If letter states, my lord, if it is not, my lord, in other way, my lord, it is sometime, my lord, it is paid to make submission, my lord. After hearing on the merit of the case, my lord, admittedly, my lord, matter will be decided by the title suit. That is one aspect, my lord. Had it been the case that, my lord, title suit has not been filed before this writ petition, then matter could have been different, man. But this has been filed in first, and that is the subsequent development, man. So therefore,
My
my
lord,
lord, let
my
the
lord,
affidavit
my lord,
come, my lord.
in any case, even if that is the case,
You're for the private respondent?
yes. Arunachal Pradesh Land Records Act, Chapter 11, my lord, Section 95, my lord. Proviso will be important. Anyway, my lord, Section 95. No suit or proceeding shall, unless otherwise expressly provided for in this act or in any law for the time being in force, lie or be situated in any civil court with respect to any matter arising under the provisions of this act, provided that if in a dispute between parties a question of title is involved, a civil suit be brought for the adjudication of such question, my lord. My lord, had it been, because this is only pertaining to preparation of records and other things, which is not subject to the civil court. It has to come to the High Court. However, if a title between the two parties, because in this case, if it is regarding with government, then it is not maintainable in the civil suit. It has to come to the High Court. Now, since this is totally a private affairs now, so therefore,
Yes, he has a point, but let her file, she is willing to contest, let her file. This has not been admitted, so I won't admit it.
Yes.
Let her file the rejoinder.
Correct.
File a rejoinder. Affidavit.
well, in that case,
Affidavit in
in that case,
opposition.
a specific date may be fixed, and if the government
My
does
lord,
not file
my lord,
the
why I'm
affidavit, by that time, the matter may be disposed of on the question of
My lord,
maintenance.
why I am submitting, my lord, there is no procedure as prescribed by the state government for to follow the, my lord, the procedures before issuance of the LPCs, my lord. That has to be clarified by the state. There is no procedure as such. The procedure which has at all not prescribed in the format by the state government, my lord, that cannot be imposed upon to me, my lord. It is none of my violation, my lord.
No, my lord. My lord, the ADC was acting as a quasi-judicial authority, was to find out whether this land belongs to him or not. But procedure were not maintained. It was done in a very, very surreptitious manner. And when the actual additional deputy commissioner, the LPC were not issued by the additional deputy commissioner, it was issued by the extra assistant commissioner in the name of the ADC. When he came to know about it, so he decided that this is not the procedure followed, and this is not the way to do it, because basic principles of natural justice also was not followed, and therefore, since it is a quasi-judicial magistrate, when he found that the matter is not sustainable, he had taken the decisions to recall the order and cancel it. There is nothing wrong in it. Anyway, my only response submission is that since this is the only issue which is keeping the case now, let it be fixed on a particular date and giving them 10 days or 15 days time. And if it is not filed, then also, my lord, the question of mentality should be. Otherwise, my lord, it's a lower court there. In their title suit also, they have quoted this pendency of this court with this case. So it is playing
Yes,
in
yes,
the
sir.
mind
That
of
I understand.
yes.
So one fixed date then, one fixed date, yes. Mr. M. Kato, learned counsel for the
Petitioner, my lord.
petitioner is present. Mr. T. Patin,
Yes, my lord.
learned counsel for the private respondent
Okay, 24.
is present. He has submitted on the issue of maintainability of this petition. It is submitted that this petition is not maintainable.
24.
Ms. R. Basar, learned government advocate, has prayed for some time to file affidavit in opposition. Mr. K. Kamduk, D. Kamduk, learned counsel land,
Yes, sir.
learned standing counsel
Yes, sir.
land is present. The learned government advocate may file affidavit within a week. Please the matter.
24, my lord.
Weekday.
My lord, state respondent, my lord.
State
State respondent
the
also.
state respondent may file affidavit within 1 week. Leave the matter after. 24th,
And my lord,
24th.
and my lord, may I pray that my lord, I may be allowed to serve a copy to the Secretary Land Management personally, my lord.
Secretary Land.
It's because he is the my lord, head of the department who prescribed the rules, my lord.
Copy of the affidavit.
No, my lord, copy of the read petition may be allowed to serve upon the.
Learned Counsel for a petitioner is allowed to furnish a copy of the read petition to the Secretary of
Land Management.
Land Management. All right. Why? What was the basic
That's
reason?
because in the prescribed my lord procedure,
Ah,
My lord, when the
there is a
government is filing
prescribed my lord
affidavit,
rules, my lord. Rules, my lord, as I pointed out, nothing is mentioned, but
Okay. I got your point. Yes. Yes.
development.
Maybe listed for admission hearing.
Yes, it will be listed. It will come up for admission hearing. List the matter for admission hearing.
My lord, let the affidavit first come. Affidavit, my lord, has to become, my lord.
It is in the admission column. It's in the admission column. Already in the admission
My
column.
lord. Development.
Lordship, I am on behalf of T Tagum, Standing Council for Education. As per instruction, we have sought for the parawise comment. However, parawise comment has not come.
Okay,
Therefore,
okay.
we need to file counter affidavit. We required at least 3 weeks.
You're waiting for Paravas comment.
Yes.
My lord, on the very first day, my lord, the interim period was not considered, my lord. Only because of that reason, my lord, the time and again, my lord, they are seeking, my lord, adjournment. So therefore, my lord, may I pray, my lord, some specific date may be given, my lord. The service of this, my lord, the old lady has been discontinued by impugn order, my lord. So therefore, my lord, this caused serious prejudice to the livelihood of the family members of this petitioner, my lord. So therefore, my lord, at this stage, my lord, so that may be given, and in the event, my lord, if it is not considered, my lord, at least to that extent, my lord, considering interim, my lord, protection, like my lord, allowed to serve in the department, my lord, unless matter is executed. My lord, after termination, my lord, I am no way, my lord, even,
So I'll pass a conditional order then.
my lord.
Lordship, there are as many as 40 writ petition related, connected to this case. Therefore, even
But
the matter which I had mentioned,
she is an old woman.
My lord,
Her family depends on her and time is running out, honestly.
my lord.
When he is stating that she's an
Exactly.
old woman. So you must submit your affidavit.
no, we'll file, certainly we'll file. For that reason
Why do
only,
you need a parawise comment?
for that reason only,
You
at least
can
3
file your
weeks.
affidavit on your own.
My lord.
Then
You are
after-
sending it to government, land,
No, I am on behalf of T Tagum, Standing Council for Education.
education, okay. You'll have to obtain parawise comment, can't help it.
Certainly, I will.
Can't help it,
Well.
we have to obtain because it's in the official capacity.
Correct.
If not 3 weeks, at least 2 weeks.
Yes, 2 weeks.
Well.
Learned Counsel Mr. M. Kato is present on behalf of the, this is item number
5.
5. Behalf of the petitioner and Learned Counsel Mr. So-and-so
Arku.
is present on behalf of Learned Counsel Mr. T. Jamo representing the sending council. T. Jamo,
T Tagum, Taba Tagum.
T. Tagum, comma, for
State
Standing Council for Education Education, Standing Council for Education. The Learned Council for the respondent has prayed for time to file, or has prayed for time to file affidavit as as they are yet to receive the parawise comment from the department. List the matter after 2 weeks for affidavit positively without fail.
My lord.
Much better.
Deeply obliged, my lord.
Item number 8 and 9.
Policeman. I am in item number 8. First of all, item number 8 is IA to be taken up together in item number 9. But the another IA 175 will not use at this stage because this is praying for vacate of the earlier interim order. So this will be not taken into consideration. But IA item number
Or this
H.
for vacation of the interim order.
Yes,
Okay.
so this will be,
Vacation of the interim order, which was ordered on the initial first day.
Yes.
Okay,
that's,
staying the transfer.
Lordship.
Mm.
yes, since the case is,
In fact, Lordship, this
since
matter
the
is,
interpreter is going to dispose of today, so that will not necessary. But in case of this IA number 15,
Decided on,
my lord.
this will
No.
be decided, I think, together,
Lord-
it can be
Yes,
decided.
So, what is IA number 15 is, my lord, this is the subsequent document. IA number,
Yes, that they have gone through those documents.
yes,
Uh,
that the
that,
subsequent document
That
wherein it is stated that the,
findings of the committee.
yes, the,
I've gone through those documents that day.
my lord, that has
Findings of
been,
the committee is.
committee has already discussed that response. So, my lord, in this view, now the matter pertaining to the, my lord, this allegation has already over, that chapter closed. In such situation, my lord, I will not submit much. Now, the interim order passed by this honorable
You have
court,
got a private respondent,
I am for respondent number
R5.
5, yes. Therefore, this is the case where material has been suppressed. What I would like to add, the one thing is that the
So,
impugn
you
order
see,
was passed. Thereafter,
You are not prejudiced. Their main case is against the department.
yes, Lordship.
Their main case is against the department.
In
exactly.
fact, Lordship, he is,
You are in a very good place, Naharlagun,
yes, Lordship.
and there is nothing against you. The main case is against the department.
My lord, that
If the
is there.
department say-
But let me, my lord, one complaint, my lord, is because, my lord, because of this false allegation, because of this complaint, I have been transferred from the Mohanbari to Norlagan within the month of, my lord, 8 months. My transfer should not have been, my lord. My transfer was because of the complaint only. So I am the, my lord, the person who victimized on the basis of this
But
false
this is not your case. You are a
false allegation.
respondent. You are a respondent. This is not your case. Their case is against the government.
Government, but
Against you,
Egg-
basically.
exactly,
order
yes,
of transfer.
against the government on the ground that they during pendency of the investigation of that.
We'll hear them what they have to say, government, what to do. She wants the transfer, her transfer to be stalled, I believe. And she wants to continue in Mohanbari.
Yes, Lordship.
That is it. That is it. That is what she wants. What do you have to say?
Yeah, report of Your Lordship, I have already submitted your Lordship. Your Lordship may come to our affidavit, Your Lordship, page 12.
Page 12.
Yes, para
That
11.
in IA?
No,
In that main
I'm not
case.
the party, Your Lordship, in the petition.
You're not a party,
No, in IA, Your Lordship.
not in the IA.
Yes, in read petition.
Read petition, yes. Page 12, yes.
Page 12, here, Your Lordship. Here, actually, Your Lordship, the matter become infraction, Your Lordship.
It has
The
become
petitioner
redundant, yes.
allegation investigation has been completed, Your Lordship.
All right, then we'll pass an order.
Lordship, in the small reply, Lordship. In the last occasion, I was supposed to make a reply subject to the submission made by the parties,
Okay.
Lordship.
Yes, what is your reply?
Lordship, my simple reply is that, Lordship, since they have submitted a judgment that 2009 to SSE, Lordship, in the last occasion, Lordship. It's clearly stated that any order which has been passed without having a jurisdiction, Lordship, it's nullity, Lordship. It's null and void only, Lordship. And so far as the transfer order is concerned, Lordship, they invoked it OM dated 9/9/2016, Lordship. On the basis of para 3, Lordship, on the basis of that OM dated, Lordship, they have issued an impugn order, Lordship.
No. That she has given a reply that it was a transfer policy, but not on the basis of your complaint. She was not transferred. It was normal transfer,
In
not on
that-
the basis of sexual harassment
Lordship.
complaint.
In that case, Lordship, kindly come to the page 36 for a moment, Lordship.
Page 36.
Page 36, this is the impugn order, Lordship. If this transfer order is a normal transfer order, Lordship, on the basis of procedure established by the department, Lordship. then I would have not
Page
opposed
36 where?
page 36 lordship, Annexure J lordship, in the main petition lordship. that
Annexure?
petition. Annexure J lordship.
Yes, yes.
Yes,
Main
Lordship.
petition.
Yeah, Lord.
Which part?
Lordship, there's only this first paragraph, Lordship. Consequent open the ongoing inquiry over alleged sexual harassment between so and so, so and so. OM,
Page 36, we have only page 32.
page 36 of the main petition, Lordship, red petition.
Running page.
Page 36, Lordship. Petition. Main petition.
Annexure 10, this is the running.
Annexure J, Lordship.
So, cannot find page 36. Annexure, no, these are annexures by the government. For the government.
Yeah.
Oh, why I couldn't find this? Page 36.
Page 36, Lordship.
Yes,
Yes, Lordship.
yes, page 36.
Page
Yes.
36. This is the main order, Lordship, which is being under challenge before your Lordship. The improving order, Lordship, this order has been specifically passed, Lordship. After this incident, Lordship, after the sexual harassment was meted out by the private respondent, under petitioner, Lordship. If your Lordship will see, para 3 of OM dated 9/9/2016, Lordship. I would like to take again your Lordship kind attention to the OM dated 9/9/2016, Lordship. Lordship will find it page number 38, Lordship. Page number 38, para 3, Lordship, which has been
Further to ensure fair inquiry, Ministry Department may also consider transferring the suspect officer to another. So that, according to them, they have already replied, no? According to them, that first transfer is because of the charges. And the
Lordship.
second offer is, second matter is general transfer because there was, after that Mohanbari, I think nobody is required at Mohanbari now because this airport has been constructed at Holongi.
Holangi Airport.
So Mohanbari, I think many employees are not required in
Yeah.
Mohanbari.
Now-
So they have transferred to rowing where there is dearth of employee. That is their answer.
Lordship.
Huh.
Now, Lordship, since my humble prayer before your Lordship is there, Lordship.
This is under their transfer policy of that department, transfer policy.
Lordship. Now, Lordship, since this transfer, my transfer, Lordship, specifically my transfer has been issued by the department, Lordship. Only on the basis of complaint I have been made before the higher authority, Lordship. That is what I'm trying to say, Lordship. Because
but,
if
Please read page 36 there,
Lordship,
where it is specifically mentioned.
Lordship,
Where is it specifically mentioned?
Lordship.
Please read.
may I read, Lordship? Consequent open ongoing inquiry over alleged sexual harassment case between Srimati so and so Mohanbari as accused and in order to ensure fair inquiry by the internal committee, Lordship, as envisaged in a sexual harassment of a woman at a workplace, Prevention Prohibition Redressal Act 2013. Full stop, up to full stop, para 3 of OM dated so and so, transfer and posting arrangement of the following officer with immediate effect are made as follows.
Yes, yes, they have a point.
But still, in your Lordship, inquiry has been done, your Lordship.
Now my humble
And the-
submission is, since the inquiry has been done, Lordship. And now as per the affidavit filed by the respondent and the department, Lordship, private respondent and the department, Lordship. The allegation which I have been levied against the private respondent number 5, Lordship.
So he is transferred because of, that lady is transferred because of this allegation.
Lordship,
So this allegation and you are relying on the decision of the Supreme Court? The relevant paragraph?
para 26, Lordship.
You have to convince this court.
Okay, your Lordship.
This way or the other way, you have to convince this court. See, your answer is
still-
not satisfactory. He has a point.
Yes, sir, but in our, from our affidavit, Your Lordship,
In your affidavit, you
Yeah,
have
it's a
stated, but
routine
he-
transfer,
now
Your
he has
Lordship.
stated that, now he has shown me that I have missed, I don't know, I have missed it that day, that this transfer is after the inquiry.
Lordship.
That day, you did not reply, so I have missed it
Lordship.
actually.
Due to paucity of time, Lordship, I could
Yeah,
not
could
reply.
not reply, I
Lordship.
have missed it.
Lordship.
So I can give you some time to reply
Okay,
today
then, Your
or
Lordship.
not tomorrow, but not tomorrow. Tomorrow, today you'll have to reply.
By this order, Your Lordship.
I'll
Or-
give some time.
Lordship.
Okay.
Maybe at 2 you can come up with a reply. See, he has a supporting decision of the Supreme Court.
My lord, I have to add 2 to 3 line, my lord.
No, you are not
No,
required.
my lord, I am the.
No, why?
Purpose.
No. He has nothing against you. He is more on her transfer.
Exactly. Well, my lord, allegation,
Then
everything is against.
if you are against the transfer policy, you'll have to come with another petition. You are not required to reply, not at all.
Even then, my lord, one thing may be recorded in support of my argument, my lord.
Hmm.
2010 SCC.
Hmm.
2010 volume 2.
2010 volume 2.
SCC volume
Oh.
2, page 114.
Please give me this set, judgment.
The-
Page
114,
114,
para 4 and 8.
para 4 and 8. What are the parties?
Party name, Dalit Singh versus State of Uttar Pradesh and others.
Please give me the judgment, if you can. Dalip Singh versus State of Uttar Pradesh.
Very clear that, my lord, the petition basing on the suppression of the material facts is, my lord, need to be, my lord, deserve to be dismissed, my lord.
What suppression? There is no suppression.
Suppression is there, my lord. My lord,
What
the
suppression?
moment, my lord, when transfer order was made, thereafter he was already released. The
No,
subsequent
you are not prejudiced, you are not aggrieved here in this case.
So-
He has this case, I don't know why he has made you a party. He has this case basically against the other party.
In fact, Lordship, he is just a pro forma defendant.
Yeah,
Lordship.
pro forma default.
But, my lord, I am the person who is suffer out of this complaint, my lord.
No, you are not,
I have
suffering,
been
you are posted
transferred.
at Naharlogan. How can you be suffering? Transferred. So he has a judgment which is supporting his case. Please read the relevant part also. And you can supply a copy. Huh?
4 and 7.
Which one?
Dalit Singh.
Para 4 and 7.
Yes. Clean hands, it's for separation of material parts.
We are on that Lordship 2009 judgment, Lordship. The judgment which I have submitted before your Lordship.
So after 12 then?
No, Your
Or
Lordship, actually, I need to get instruction, Your Lordship, for the department. This one,
In fact, Lordship, department has already filed their affidavit, Lordship. It's evidently clear that only on the basis of that, they say that there is a transparent policy guidelines, Lordship. Now, my contention is that, Lordship, since the transparent policy guidelines, if
You
this order,
concluded today, you concluded today.
Lordship,
yeah. Okay,
No
Your
instruction is
Lordship.
required. You have already given an affidavit.
Not
Maybe
sure,
I'll hear you
yeah.
after 2. Or after 12.
After 12, Your Lordship.
After 12, yes. I'll hear you after 12.
Lordship. Deeply obliged. Lordship.
Leave it as it is, because I have some notes also. Day 2, I think day 2.
May your
Bring the
lordship,
citation, huh?
may your lordship, lordship in item number 11, there was interim. So
This is 7, just a moment, this is 7 and 8. Huh? 8 and 9. We'll take it after 12. 11. Yes, item number 12,
11.
11.
Yes, there was interim. So interim may be.
Item number 11.
Yes.
This morning he was mentioned, as he was mentioned,
Already
but,
adjournment was taken in item
but
number
there is
11.
interim order,
Yes, yes, interim
so
was
he
there.
is seeking
Okay,
for
okay,
interim.
interim may be continued.
Okay, that will remain in force.
Yes.
Oh, you have taken adjournment.
Yes, yes.
Maybe I forgot.
And in item number 12, your lordship, we won't be filing our rejoinder. But the
Rejoinder.
Yes,
But then this matter may be disposed of with a direction to the respondent authority to verify the record, since there has been material losses from my side.
You file rejoinder?
No, I won't be filing rejoinder.
You won't be filing
Yes,
rejoinder, okay?
yes.
But this matter may be disposed of today.
Yes, dispose of with a direction to verify the record as to whether there is anything payable to me. Since I was executing the work and I have even deposited my earnest, performance granted of 4 lakhs rupees.
May I please, my lord. My lord, communication has been made, but no instruction has been received yet, my lord. Therefore, 2 weeks time may be given.
Let him receive instructions. If he gets the instructions and if it is favorable to you, then we'll dispose it on that day itself.
Yes.
Learned Counsel, Miss so-and-so is present on behalf of the petitioner, and Learned Counsel, Mr.
M. Sora, on behalf of M. Kato.
Sora is present on behalf of Learned DSGI, Mr. M. Kato, for the respondent. Full stop. The Learned Counsel for the respondent has prayed for 2 weeks' time to obtain instructions.
Yes.
Full stop. Prayer is allowed. List accordingly.
Deeply obliged.
May I sign, madam? My lord will kindly have a look at the order dated 5/1/2024, my lord, passed by this honorable government. Order dated 5/1/2024, my lord.
5/1/24.
5/1, madam.
Oh, this is the older one.
Yeah, my lord will see also next order, my lord, 14/2024, my lord.
Yes.
May I please, Your Lordship? Your Lordship, there is some discussion has to be done on this issue, Your Lordship. That is why, Your Lordship, it's taking time. Otherwise, Your Lordship, we have received our instruction. We'll be filing it today or tomorrow.
Last chance already given, my lord, on 2 occasions, my lord. Their administrative inconvenience, my lord, cannot be granted for, my lord,
They'll file
violating-
it today. You file it today. Let them file it today.
my lord. Let them file today, my lord, and in the
Yes,
meantime,
they are filing
next date, my lord, this may be listed in admission column, my lord. Even if they.
It's at the admission column.
No.
Your Lordship, I'm for respondent 2 and 3. We need some more time to file our affidavit because we need some instruction from the respondent. So, I'm for tourism department. In fact, the senior, he went to attend a meeting today just to get instruction. So we won't be able to file
Meeting is
our.
happening today.
My lord, he is seen in.
Our senior also went to, for this purpose only our senior went to. attend the
Yes.
We
meeting.
need to have a look at order dated 5/1 and 14, my lord. Other this submission, my lord, would not have
So
been.
you will have to.
Last
also have to
opportunity may
consider
be
you see
given
our
your-
Seniors in the meeting only for you,
Yes.
for this purpose.
Yes, Your
My lord,
Lordship.
that can, this is not, now this is not between me and them, my lord. This is between the court and them, my lord. Court has
pass a categorical order given some last chance, my lord, on 2 occasions, my lord. If they are not interested, my humble submission, my lord, next day, let the
Next.
better
It is-
admission column.
It is her submission, I'll record it.
Last
And then I'll give
opportunity.
them time.
They,
It is her submission, I'll record it. Her senior has gone to attend the meeting only to obtain instructions.
my lord,
Hmm.
I have no
I'll
objection
record
about the granting of time, my lord. My humble submission, my lord, let them give a time, my lord. In the meantime, my lord, next day, this matter will
She's
be
filing
admission
it
column, my
today.
lord.
She's filing it today.
Yes, my lord. One is filing today, my lord. Other is seeking some time, my
She's
lord. I have
already
no
opposed
objection,
to
my lord.
meeting.
But then matter will be stated in next date in the admission column. Let it be after 2 weeks, my lord. If they do not file after 2 within 2 weeks, my lord, the matter can be disposed of, my lord. Already there is two order, my lord, by this order.
Already there are orders.
Order, my lord.
We're speaking orders that it will be disposed.
My lord. So my humble submission, next date, this will listed in admission column.
Learned Counsel Mr. L. Parme for the petitioner is present. Learned Counsel Miss
P. Sangeeta, your lordship.
P. Sangeeta is present on, Learned Government Advocate.
Yes,
P.
yes, sir.
Sangeeta is present.
Yes, on behalf of respondent
On
number
behalf of respondent number
1, 5, 6, 7, and 8.
1, 5, 6, 7, and 8, Learned, Learned Counsel Miss
A Talom.
A. Talam
Yes.
is present on behalf of Mr. Opada.
N Pada. N Pada.
N. Pada.
Yes.
N. Pada, Learned Counsel for the Learned Standing Council Tourism.
Yes.
Learned Standing Council within bracket tourism. Full stop. The Learned Government Advocate has submitted that today they will file the affidavit in opposition. The Learned Counsel Miss
A Talom.
D. Learned nahi हाँ stop करके Learned Counsel Miss A. Talam has submitted that her senior is attending a meeting to obtain instructions so that affidavit in opposition can be so that affidavit in opposition can be filed. The 2 weeks time is accorded to the respondents number 2 and
3. 2 and 3.
2 and 3 to file their affidavit, list the matter for admission positively on the next date fixed. I'm giving a day.
After 2 weeks, my lord. It will be 2 weeks will do, my lord. No, it's
Then list accordingly.
2 weeks.
List the matter after 2 weeks.
Obliged.
List the matter accordingly after 2 weeks.
Obliged, my lord.
Obliged.
For admission positively. For admission, for hearing on admission positively. Without fail, without fail, failing which orders will be passed on merits of this case. Necessary order will be passed on merits of this case.
Obliged.
Item number 15.
My lord, in this case, responses have filed affidavit.
Hmm.
I want to file rejoinder. So I may be given 2 weeks
Alright,
time.
Learned Counsel Mr. S. Koyan
Yes, ma'am.
has submitted that he will file rejoinder against the affidavit in opposition filed by the respondents. Learned Counsel Mr.
And Sora. On
N.
behalf of
Sora is present on behalf of
M. Kato. For respondent
Learned
number.
DSGI.
Yes, ma'am.
Mr. M. Kato, Learned Counsel Ms. K. Learned Government Advocate Mr. K. Wangmo is present on behalf of respondent number
5.
5. Learned Counsel Mr. D. Kamduk, Standing Counsel Land Management is present on behalf of respondent number 4. So Mr. M. Kato is for respondent number 1, 2, and 3.
2 and 3.
1, 2, and 3. No? This is the matter
After 2 weeks.
after 2 weeks.
Obliged.
Item number 15.
Dear my lord, respondent number 1 and 2 are supposed to file their affidavit.
Mm.
Rest we have received. You mean comment? One or two appointment.
They have not filed.
And Your Honor,
Only respondent number 4, 5, 6, 9, 10, 11, and 12 have filed.
rest we have received.
Yes, my lord. I am for Union of India, my lord.
You are for
Union of India on behalf of M. Kato, my lord.
M. Kato.
Yes, my lord. 3 weeks time may be given to file affidavit, my lord.
My lord, they have been taking adjournment since 10/10/2023. my lord. In 3-4 times already taken adjournment for filing.
Learned Counsel, Mr.
Remove Riverman.
Huh?
Remove Riverman.
Remo Riba.
Yes, my lord.
R Riba is present on behalf of the petitioners. Learned Counsel, Mr. R Sora.
And Sora.
And Sora on behalf of Learned Counsel, Mr. Learned BAGI.
Yes.
M Kato is present on behalf of respondent number 1. Only one?
1 and 2.
Huh?
1 and 2.
Respondent number 1 and 2,
Yes, madam.
comma, UI, comma, and Learned Government Advocate Miss K Wangmo is present on behalf of respondent number 3 to 12. 3 to 12. Stop. The Learned Counsel, Mr. R Sora.
And Sora.
D nahi, huh? Learned Counsel, Mr. N Sora has prayed for 2 weeks time to file affidavit in opposition. List accordingly.
This may be last opportunity.
The Learned Counsel for the petitioners has raised objections stating that several adjournments have been taken by the UOI have been granted for UOI to file affidavit. Full stop. A last opportunity after hearing the submissions at the bar, comma, a last opportunity is accorded to the UI to file the affidavit in opposition positively after 2 weeks.
Deeply obliged.
Item number 22.
Why nobody is appearing? This is an old matter, 2018.
This is for non-prosecution, some fine maybe. Let them-
Oh, quarter. He was maybe chucked out of the quarter, maybe. Quarter. Illegal occupation of quarter, maybe chucked out of the quarter already. He will be homeless. All right, 2 weeks time. The none appears for the parties on call. List the matter after 2 weeks.
Item number 24.
Lordship, I would like to pray for adjournment. in this case, Your Lordship.
Yes, yes, item number 24, yes.
Number 24.
There's some disturbance on this
I'm
side.
appearing in this
from-
case for the first time. I'm for the petitioner. I had a
Disturbance in
discussion
the
with
link,
my, my lord, can it be fixed on 38?
Oh, asking for
Thirty-
seeing Lordship. As agreed by the learned counsel for both the sides, all right? Or should I mention, record your names? Learned Advocate General, Senior Counsel.
Dita.
Private capacity.
Yes, ma'am.
No, senior
No.
counsel, no.
Learned
counsel.
Senior Counsel for the petitioner. Present.
For respondent number 2 and 3.
Learned Counsel Miss
Arbasar, Lordship.
Arbasar is present on behalf of respondent number 2 and 3.
For 1.
Learned Counsel Miss N. Anju
Lodge.
is present on behalf of respondent number 1. As agreed by the learned counsel for both the parties, list the matter on. When do you want?
38, 30. 38, 30.
30th. Yes, 30th May.
Yes, of this month, Yes,
Yes.
Yes, my lord. Okay. I know, no, it's the biggest problem.
So I'll come after 12 then.
Lordship.
We'll dispose that matter, your matter. You come, after 12, you come, okay?
Yes, my lord, right from the interim order,
Page 36.
page 36.
I've
My
seen
lord,
it, yes.
reason for transferring is given there.
But you're saying that this is not a reason for transfer.
I'm sorry, my lord.
But you're saying that this is not a reason for transfer, according to you.
This is one of the reason, my lord. So that, my lord, fair inquiry could be done. Here, my lord, both alleged accused and the complainant, they have been transferred out from Mohanbari. Now, my lord, accused is, my lord, is higher.
Fair inquiry can be facilitated.
Yes, so that they don't manipulate the evidence, so that they do not make any undue influence, my lord. For that purpose only, my lord, it was transferred out. Now, my lord, petition has been filed saying that this transfer order violates the, my lord, that Harassment Act 2013. My lord, it is very true. As per the section 12, subclause 1. My lord, on the basis of the complainant,
That sexual harassment at workplace. Sexual harassment of.
2013.
Fair inquiry can be facilitated, yes.
Yeah, it's there. 2013. It's a central act. Barrack में मिले. You have, इसको दे दो. Now, as per the section 12(1), my lord, it is the complainant on written request, then only, my lord, his or her transfer can be done. But while doing that, my lord, the transferring authority has not obtained any written or any oral or any approval from the complainant, my lord. That is the reason why the Honorable Court interfered with the transfer order. We also, my lord, later we also did not object because that violates the act very correctly, my lord. So that's why based on that interim order was passed. Now you see the transition during pendency. The section 12 clearly says during pendency, my lord, the complainant cannot be transferred out, but only if the request is made by her or him or written. Now, during the pendency of this litigation, now inquiry has been completed, report has been submitted, and if the complainant is against the report, there is a 90-day grace period for appellant, my lord. That is also lapsed. Report is against the complainant, saying that there is no any prima facie evidence found during the inquiry. So allegation against the officer or exonerated, my lord. So inquiry was closed with that note that there is no any
90 days, where is the period of?
from the date of
limitation period?
from the date of inquiry report, my lord. I think it's there.
Where? Limitation is only 90 days for appeal, no?
Otherwise also, the basic foundation was that based on 2013 Act, during the pendency, complainant cannot be transferred out. That was the reason only. For transferring of his or her consent or written letter written for transferring is required, my lord. So there is only that condition, my lord, we have not compared. Because of that, court said no, that's violative of article section 12, my lord. So we said, all right, let there be interim order so that we can complete the inquiry. Now, inquiry has been completed, report has been submitted, saying that there is nothing adverse. Now, the basic allegation made in the petition has become partially infractious because inquiry is already completed. So against that inquiry also, there is no against appeal has been filed. And another.
So where is the limitation for filing appeal?
Appeals 18, my lord. Subclause 2. Page 13. Has your lordship got it? Appeal 18, subclause 2. The appeal under subclause 1 shall be prepared within the period of 90 days from date of recommendation. Now, another concealment of fact. In the petition itself, in paragraph 11, the contents of the petition is that she has not been released out, whereas that is also wrong. She was released out from the Mohanbari so that she can join rowing. Because at that time, rowing there was no DRC. Rowing there, huh? No. District क्या होता है उसको? The post?
Joint.
No, no, no.
Civil supplies.
Yes. Drawing there was no food and civil supply officer was there. So vacancy was there. So again, the vacancy post, she was transferred out. So that fair inquiry can be conducted. My lord. That is only the reason that she has been transferred. She was transferred out. And not only the complainant, even the accused was transferred out.
So appeal is to be preferred before which court? Any person agreed from the recommendations made under subsection 2, then this is not part 12, not 12. Subsection 2 of section 13.
Appeal mala section 12, 18 mala sub clause 2.
Please read. This is not any person agreed from subsection 2 of section 13.
Clause 1 says mala any person agree from recommendation made by sub clause 2 of clause 13 and clause 1, clause clause
No,
2.
this is on the findings of the committee only appeal can be preferred.
No, sub clause 2, my lord. Sub clause 2 will be very clear. My lord.
Sub clause 2, yes.
The appeal under
Whether
sub clause
internal
1.
committee or local committee as the case may be arrived at the conclusion that the allegation against the respondent has
Yes.
not been proved.
Recommendation because committee has completed their.
No, you cannot stretch it that far. No.
I'm sorry, my lord.
No, you cannot stretch from 2 to 12. You cannot stretch that far.
No,
No,
appeal,
no.
appeal provision, my lord. You lost it to
Appeal,
read both. You lost it.
There is no provision for appeal in under section 12.
No. Appeal is under what circumstance, my lord, the employee can be transferred. Both, my lord, accused and the complainant. You lord, can see.
Sub clause 2, yes.
Yes.
On the
Sec-
findings.
Section 12, my lord. During action during pendency of the inquiry. Has your lordship got it?
Yes.
Chapter 5, inquiry into complaint. Section 12, action during pendency of inquiry. During the pendency of an inquiry on a written request made by the aggrieved woman, the internal committee or the local committee, as the case may be, recommended to employee to transfer the aggrieved woman, or the respondent to any other place. Here is the main content in my lord, written request, my lord. So written request has to be given by the accused so that please transfer me out of this place. That was not done. And because of that, my lord, that violates this section 12, my lord, clause 1. That's why that is the reason why the Honorable Court interpreted with the transfer order. So stay order was granted. So later on, we also came to know, yes, it's a prima facie, there is a violation of section 12, my lord. Now, the main thing what? During pendency, another aspect, my lord. Now the inquiry is completed, my lord.
So appeal can be preferred only against the inquiry report.
Yes, my lord.
Okay, so you are correct then.
Yes.
There is a provision for appeal.
Yes. So any recommendation if the company is agreed, my lord, he or she can lodge he can file an appeal within 90 days, my lord. So that part also lapsed, my lord. But having saying all these things, my lord, now the government employee, my lord, now as per the transfer policy also, the minimum period is 2 years, my lord, 2011 or 12, my lord. The tenure for transfer posting is 2 years. Earlier it was 3 years, my lord. Now 2 years. Now 2 years also left, my lord. She has completed more than 2 years in Mohanbari.
Tenure for what posting?
My lord, any post.
Okay. That
Any
is
post.
the transfer policy.
That is the transfer policy adopted by the state government, my lord. Earlier it was 3 years. Now they have been cut down to 2 years, my lord. Now this is not the case that she has not completed in normal tenure. Only the harping on only this act, my lord. There is a violation of clause 12(1). My lord. So the Honorable Court take the cognizance and interim order pass. We also did not raise any objection because inquiry was pending, my lord. Now the position is the inquiry has been completed, report has been submitted.
All right.
So the method become, my lord, yes. There is no further education is required, my lord, in this case.
I'll pass an order then.
Lordship, the section 12, it's clearly stated that only the written request by the aggrieved woman only.
That's
Not
what
the
I
prior
said.
respondent, Lordship.
He has stated.
Yes, Lordship. And so far as Lordship, the OM dated 99/2016 in Skirson Lordship. It only says the suspected officer, not the aggrieved woman Lordship. Now my humble submission is that Lordship, if this order is interfered by this honorable court, by way of setting aside Lordship, they can still have an opportunity to pass a fresh transfer order Lordship, as per the guidelines Lordship. There is no bar for them. Lordship. Now my only concern is this transfer order has been passed without having a jurisdiction, while the respondent authority ought to not have passed this transfer order after filing of the complaint by me Lordship. That is the only thing. That's all. Lordship.
My lord, reason we have said, my lord, once the complaint was lodged, my lord, now how to make a fair inquiry, my lord, without any undue influence, my lord. So that is the only best option to transfer both the, my lord, complaint and accused. That was the only reason, my lord.
See, if the order is set aside and quashed based on the guidelines of the Honorable Supreme Court, in this case, which he has supported, if the order is set aside and quashed, then I will not pass any order for directing them to transfer her back or this and that, because I cannot. Through this writ petition, I cannot. I can give a direction that you consider her prayer for transfer as per terms and conditions of the policy.
Exactly.
Transfer policy.
Yes,
No, my
No,
lord.
you do not want the order to be quashed.
No.
But
that-
direction can be given. Without quashing the order also, direction can be
No,
given.
no, it has to be interfered, otherwise Lordship.
My lord,
this-
no
this-
deduction is required. Your lordship may simply says, my lord, based on the impugning order which was passed on 7/8/2003, partially that become infraction because, my lord, inquiry is already completed. Now, my lord, since the inquiry is
No.
completed,
You have already committed a wrong. So that can be undone, can't be undone.
my lord,
Now it has become infructuous, but wrong has been done before it was infructuous. That order was passed. So you do not want the order to be set aside and quashed. This is what you are stating.
or else your lordship may say, if your lordship interfere with the transfer order, then your lordship may give
I
the,
won't interfere.
yeah,
I won't interfere with the transfer order. This is not possible also through writ petition.
mhm.
I can only give a direction to the department to consider her transfer, to consider her prayer. If she so desires to apply for transfer, then to consider her prayer, that much, only that much.
My lord, seeking for transfer only, my lord, during the pendency of the inquiry as per section 12(1). Now that period also lapsed, my lord. The inquiry is completed, my lord. How can, my lord, the complainant can apply the section 12(1), my lord? He can't. Because inquiry is completed, my lord.
Lordship, I
No,
will-
you,
Yes.
both of you give me a solution.
Now only
Both of you give me a solution.
Now, so far as the
Like-
Lordship, the law,
एक minute. Now your lordship may either say,
As per law, within the.
Yes, Lord.
Within the realm of law.
then best option would be, my lord, your lordship may interpret with this transfer order 7/8/2003, and your lordship give liberty to the authority. If they wish, they can pass a fresh transfer order. That is the best option, my lord.
This is what I'm saying.
that's
No,
what.
you,
Lordship.
your lordship not said so, my lord.
I was asking, I'll set aside and quash.
Yes,
the-
Lord.
The order,
Lordship.
7/8/23.
Lordship.
Mm.
Yes, that's what I've been saying. I will not interfere with transfer or anything.
Only in respect of the petitioner, Lordship. Only in respect of the petitioner 7/8/2023.
Yes, of course. In
Yes, Lord.
respect of the petition, not of the respondent number
No,
5.
not Lordship,
No,
exactly.
no. My lord, this is a, my lord, tri-party transfer order, my lord. If your lordship interpret with the only, my lord, petitioner, what about the accused, my lord?
Lordship, my prayer is only in respect of the
No,
petitioner only, not for the
But-
respondent, Lordship.
We have to see, my
No,
lord, process, my lord.
That order is dated 7/8, isn't it?
Yes, Lordship.
The entire order will be quashed. So far as the petitioner is concerned, you are asking.
Yes, Lordship. There is a specific prayer made in the petition, Lordship, only in respect
all
of the
right.
petitioner, Lordship.
Follow in such situation, what will be my condition, man?
He will be considered by the respondent authority only, Lordship. Since the inquiry is completed, Lordship.
Allegation, my lord, I have been transferred. And now the complaint has been, my lord, proved that that was false. In such situation, my fundamental right to serving as a, my lord,
Otherwise, my lord, says, my lord, the,
Mohanbari has been, my lord, deprived. Now I become a man. Now it has been clear, my lord. Now matter already surfaced up.
Where
The allegation
is
was
a better
completely
place in Arunachal than Naharlagun? Just tell me. Where is a better, give me a place better than Naharlagun in Arunachal Pradesh?
My lord, that is another thing. I have been transferred from Naharlagun to Mohanbari. Now I am the person who deserve to serve there as a Mohanbari in the capacity of my lord, additional residence commission and the joint director. That has been deprived, my lord, out of the false complaint, my lord. Now I can, my lord, confidently say that the complaint was false because the complaint committee has proved there was a false, and at the same time
See,
for filing, my lord, that over.
You have come out victorious. So how, in what manner are you aggrieved?
Well, otherwise also, if your lordship asks the same question to the petitioner, my lord. Now, my lord, there is no officer in Rohing, my lord. There is a vacancy still, my lord. There is a
If
vacancy,
it is to be, my lord,
So I am not in favor of the petitioner.
my lord.
I am not in her favor.
if it is to be.
Then your lordship may kindly direct the, my lord, petitioner to immediately she should report to that Rohing, my lord.
Of course not.
Your lordship may pass the order as may, your lordship may deem fit improper.
I think for the ends of justice, but even for the convenience balance, my if your lordship, my lord, suppose interfere with this impending order, my lord, then liberty should be given to the officer respondent to take
Yeah.
precedence. Yes.
That is what I was suggesting. Pin. I have one here. I cannot reach out. ऐसे स्टेपलर एक स्टेपलर होने से हो गया. The respondents number 2 and 5 have filed affidavits in opposition. Refuting the averments of the petitioner, AVERMENTS, full stop. The respondent number 5 has stoutly denied of having subjected the petitioner to sexual harassment at workplace. It is submitted that the petitioner has not come with clean hands. Full stop. The petitioner was already released by the order dated 5/9/23 in pursuance to the order dated 11/8/2023. But the petitioner, without challenging the order dated 11/8/2023, has approached this court in a surreptitious manner, SURREPTITIOUS, concealing the order dated 11/8/2023. both the both the respondents, number 2 and 5. Have submitted that as soon as the petitioner lodged the complaint dated 1/5/2023, comma, the internal complaints committee within bracket ICC for short bracket close was constituted. Full stop. It is also admitted that indeed the respondent took charge, respondent number 5 took charge as regular joint director within bracket food and civil supplies bracket close come additional resident commissioner within bracket JT stop DFCS for short bracket close and joined on 3/4/2023 at Mohanbari in the interest of public service. The respondent number 5 appeared before the ICC and the proceedings were conducted by the ICC, full stop. Finally, the ICC submitted report on 9/11/23. Annexure,
19/12/23.
19/12/23. 19/12/23. Full stop. You have submitted the ICC report through the IA,
Yes.
through the IA.
I
You have submitted, no?
No, no, no.
Oh, no, you could not submit, yes. So the ICC report is marked as annexure. The report of the ICC is marked as annexure
11.
11 of the interlocutory application within bracket of the interlocutory application within bracket C bracket close 175 of 2023. This is the annexure 11.
Yes, in continuation.
It is
of-
submitted that the respondent number 5 has come out clean. The ICC has exonerated him from the charges by the complainant. It is admitted, it is fairly admitted that no written request was made by the aggrieved woman to the ICC or the local committee for transfer it is admitted that during the medical leave, during the medical leave of the petitioner, the transfer order was issued. Stop. However, it is contended that due, that due to that as the petitioner did not cooperate with her duties, comma, the ex parte order for taking over charge of the drawing and disbursement officer was passed. You have that respondent number 2 has written this. That the
I'm
that
sorry.
ex parte order for taking over charge as drawing and disbursement officer was passed.
Issued by the respondent number
Ah.
5, Lordship.
Was issued.
Issued by the, yes, yes.
Because she was non-cooperative.
Mm.
This is what you have stated in your
Respondent
affidavit.
number 5. Lordship.
No, you have stated.
Okay.
I'm clubbing both your affidavits together. Next prayer likha. It is contended, but it is contended by the respondents that the common order of transfer has been misconstrued. MISCONSTRUD, misconstrued by the petitioner. Full stop. It is admitted that the respondent number 5 was transferred from Mohanbari to his present place of posting in order to facilitate fair inquiry on the allegations of sexual harassment against the petitioner or sexual harassment to the petitioner. Comma, but whilst WHILST, not but. The petitioner was transferred, but the transfer of the petitioner was a routine transfer and posting policy, routine transfer according to the transfer and posting policies of the respondent authorities. All right? Full stop. At present, when the respondent number 5 has been exonerated from the charges leveled against him by the petitioner, comma, this petition, it has become infructuous and the respondents have prayed to dismiss the petition. I have considered the submissions at the bar with circumspection. I have considered the submission that the OM dated 9/9/2016 No. I have considered the submission that the respondent number 5 has been exonerated from the charges of sexual harassment at workplace. Full stop. It cannot be ignored that the petitioner was transferred out of turn and without abiding to the
Clause 12.
this is clause, no? To clause 12 of the section or clause?
Section 12, my lord.
Section 12.
Section 12, subclause 1.
Without abiding to this section 12 within bracket 1 of the sexual harassment of women at workplace within bracket prevention, comma, prohibition. No, that the Act of 2013 I have referred to as, you know, before. Without the Act of 2013 abiding to section 12(1) violating the provisions, not without abiding, violating the provisions of section 12(1) of the Act of 2013. It is also true that while the petitioner was on medical leave, the order of transfer dated 7/8/2023 was issued. As there was an inquiry going on regarding the allegation of sexual harassment, it was in that context that the impugned order was issued by the Secretary of Food and Civil Supplies, full stop. Assailing the order, the learned counsel for the petitioner has relied on the decision of Honorable the Supreme Court in Chandrabhai K. Stop BHOIR Bhoyer and others versus Krishna Arjun Bhoyer and others, reported in within bracket 2002-2009 bracket close to SCC 315. Here. Go to the spellings. Wherein it was held and observed that para 26. It is true, reverting back to this case, it is true that the petitioner did not make any such request for recommendation of a transfer by the internal committee or the local committee. The learned counsel for the petitioner has drawn the attention of this court to the OM dated 9/9.
2016, Lordship.
9/9/2016.
Lordship. Page number
To
28.
para 3 of
Para
the OM
three,
dated
Lordship.
to 9/9/2016.
Lordship.
9/9/2000 page.
38, Lordship.
Page
Correctly.
38. Page 38, huh? Usme para 3, you pick that para, entire para 3. I again lost page 38.
That impugn order, after impugn order, Lordship, the 2 page after 2 page.
Okay,
page
okay,
30
okay.
starts.
My problem is, this has come after there are two affidavits.
Lordship.
So I'm looking after the affidavits. Now I'll get it.
No.
I got it. वो पेज 38 है, ग्रीन टैग लगा हुआ है. So you that only para 3. The learned counsel for the petitioner has also submitted that the annexure J of the petition clearly reflects that the order of transfer was passed consequent upon the ongoing inquiry over LS sexual harassment case between the petitioner and the respondent number 5. The learned advocate general, additional advocate general.
Yes, madam.
Mr. Nabam,
Yes, ma'am.
the learned additional advocate R.S. Nabam, no?
R.S. Nabam, right.
And learned additional advocate general Mr. R.S. Nabam has submitted that there is no prohibition. No, you have said there is prohibition.
My lord, I have said, my lord, the impugn order has been issued basically for noble purpose, so that fair inquiry could be done. But while doing that, my lord, they have violated the section 12 subclause 1, my lord.
Has submitted that the order of transfer was passed during the inquiry proceeding only to facilitate fair
inquiry, my lord.
only to facilitate a fair inquiry.
Yes, ma'am.
Stop. It is also submitted that at present, when the entire proceeding, when the inquiry is complete.
Inquiry is
And
completed.
R number 5 has been, respondent number 5 has been exonerated, the petition is,
My lord,
petition has become infructuous or no?
the petition has not virtually become infructuous, but the grievances before this lord, before this honorable could become infructuous. Because basic submission is that,
What has become infructuous then?
my lord, basic submission before your lordship is that during the pendency, the petitioner cannot be transferred out without his written consent. That is the violative
The last
article.
sentence cut,
My lord,
cut out
now-
the last sentence. A petition has become infructuous, we cut it out, yes.
Basically, my lord, grievances before your lordship become infructuous, my lord, petitioner grievances.
Oh. Exonerated, comma.
Yes.
The grievances of the petitioner has become infructuous. In view of my foregoing discussions, it is thereby held that the order dated 7/8/2023, this is a transfer order, no? Was passed. D horse, section 12 of the Act of 2013. In the light of the decision of the Honorable Supreme Court in Chandrabhai K. Bhoyer, in the case of Chandrabhai K. Bhoyer and others, the impugned order dated 7/8/2013 is hereby set aside. The respondent authority are
At liberty to take fresh action.
the petitioner is at
Well, impugn order is set aside. But however, official respondent are given liberty to take further course of action, my lord. If they want, they can pass a fresh transfer order, my lord.
Only in respect to the petitioner, lords.
however,
My lord, not only respect, because
the petitioner's transfer order, this court cannot interfere with the transfer of the order of the petitioner. As the transfer order, however, they are, no, not how we cut it. This court refrains from interfering with the transfer order of the petitioner. Full stop. The transfer, the department's,
No, my lord, I think that will be contradictory because your lordship always
can be.
set aside and pass the
Ah,
transfer
set
order.
aside.
Only my liberty should be given to the official respondent for taking any further course of action, my lord.
Ah.
Fresh action, my lord.
No,
They can
but the
take.
petitioner's prayer has to be also considered.
Yes,
My lord, petition prayer is to set aside set and request the transfer order that your lordship is doing. But after that, liberty may be given to the official respondent for taking further action, my lord. It's up to them. If they want, they can file a fresh transfer order.
Liberty, no. I have to give some direction at least. Liberty, then
But
you-
here your lordship is
the
issuing.
petitioner's grievance won't be met.
No, here lordship is applying the mandamus, my lord, by causing the transfer order.
Yes.
Your lordship is not issuing any certiorari, my lord.
No, I won't issue
Yes.
such your.
Then, my lord, only liberty should be given to the official respondent. If they want, they can file a fresh transfer order.
Liberty.
Mas, my lord.
The petitioner is at liberty.
No, my lord. That will again, my lord, if you lordship pass, that will violate the article again, section 12, my lord. Section 12 talks about the pendency of the inquiry, my lord. Now, inquiry is already completed, my lord. That's why lordship has noted, because that impugned order was passed during the pendency, my lord.
No.
That's why lordship.
Not
is
liberty.
interpret-
The respondents are directed to, not liberty. Directed to, no. Direction also will be wrong.
No, direction will be wrong, my lord. Only liberty can grant it, my lord. It's up to them. If they want, they can pass fresh order, or if they don't want, they will not pass. order.
Other respondents are at liberty
Liberty.
to consider the petitioners, to consider the petitioner's prayer for transfer, if any, if any, as per terms and as per terms and conditions of the policies of transfer of the Food and Civil Supplies Department.
No, Malay, it's a general it's a policy, Malay, not only food and supply. It's a general policy.
General policy.
Yes, Malay.
As
2
per
years,
terms and conditions of the transfer policy.
my lord. That
Huh?
way.
There is
Yes.
no liberty also, there is nothing also may. What is the last sentence? Just read it out. Read it out. No, the next sentence you read it out. Next sentence, the last sentence. Read it out louder so that they can hear.
Malay.
Lordship, this
There-
will create a confusion, Lordship.
Therein,
this
my
order-
lordship
first
is
of all-
asking that the petitioner will make application to the official respondent for seeking transfer, my lord.
Yes.
After that, no, will be acting, my lord. No, my
Yes.
lord, that will be again problem, my lord.
How?
My lord, because he will never ask for the transfer, my lord. That is the
Then
reason, my lord.
she won't ask, then it's okay.
My lord, but she has completed a normal tenure, my lord. And your lordship will interpret because there is a violation of section 12(1), my lord. That is the only ground
I
for,
have interfered, yes.
that is the only ground for quashing the impugned
So
order, my lord.
what are you saying? What is
Lordship,
your
I'm-
suggestion?
I'm simply saying that, Lordship, this order may be
Set aside and.
set
quash.
aside and was only in respect of the petitioner, Lordship. And after that, Lordship, there is always a liberty without even seeing that in the order also.
So far as the set aside and quash, the order dated 7/8/2020, so far as the petitioner is quashed.
Lordship,
So far as the petitioner is concerned, is set aside and quashed.
Lordship.
Only relating to the petitioner, because the others are, that order has been correctly passed.
Yes, Lordship.
Very correct.
My lord.
Ah.
That's why, my lord,
Ah.
liberty should be given
Only
to the,
so-
that's why, my lord, liberty should be given to the official respondent.
With a liberty.
To the
full stop.
official
Liberty
respondent.
is given to the, yes.
Official respondent
Oh.
for passing any further action, my lord. For
Ah.
taking any further action, my lord.
Official respondents.
Yes, my lord. If they want, they can pass a fresh order, or if they don't want, they will not.
What
pass, my
type of liberty you want?
My lord, liberty, my lord, for taking further course of action, because your lordship is.
No,
passing-
no, no,
No,
no,
your
no.
lordship is interfering with the transfer order, my lord.
Ah.
Your lordship is interfering with the transfer order because there is a violative of section 12. Pendency was because of inquiry was pending, my lord. That is only reason, my lord, that impugning order passed. Because of that, his lordship was now, my lord, impugning order, my lord, now the inquiry is completed. Inquiry has been submitted. Forget about matter exonerated or not, my lord. Now, once inquiry is submitted, then section 12(1) does not apply, my lord. And further, my lord, she has only completed the normal tenure, my lord.
So what do you want now?
So
What is your prayer?
if your lordship is interfering with the transfer order, which your lordship already passed,
Yes.
now liberty should be given to the state respondent for
what? For
for
what?
taking further course of action, my lord.
What cause of action?
My lord, transferring the petitioner if
Oh,
need
okay,
be.
okay,
Yes,
okay.
ma'am. Further
Yes,
course of action.
yes.
That's only, my lord, I'm asking.
And they should be, my lord, not in respect of the petitioner. So far, my lord, transportation can, interfering is concerned, my lord.
Respondents.
They should be, my lord, in toto, my lord. Once they
How come,
interfere,
Lordship? I'm the one. who-
Respondents are at
Lordship.
liberty to proceed with the further course of action.
Yes, my lord.
Subject to the conditions of the transfer and policy.
Guidelines.
Ah.
Guidelines. That's
Subject to the subject to the terms and conditions of the transfer policies.
well. Lordship.
So everybody is happy.
My lord, everybody is happy.
And I have also not passed a wrong order then.
Because otherwise, my lord, it will, give us trouble.
No, yes, yes. So sometimes it skips your mind. You miss out something sometimes while dictating orders, you miss out. You forget also something. Like I was about to pass some other order. List is over, no?
Understood.
Oh, unlisted. What is this? Some urgent matter?
May I please, Lordship?
Yes, yes, yes.
Hello,
Again,
I'm sorry.
again,
I'm
urgent
sorry, I'm-
matter. Hope this is not
sorry to
habeas corpus again. Yes, yes,
No, no, no,
yes.
no. This is some eviction, so there is some urgency in the matter.
What type of urgency?
Lordship, before I take your Lordship to the 4 or 5 pages annexures of the writ petition, I may just indicate verbally to give the background of the case. What has happened is, in Tawang, your Lordship, the petitioner with your Lordship is occupying a plot of land. Admittedly, it's a government land. And the petitioner has applied for allotment of the land, and that application for allotment of land is pending still. It has not been rejected till now, nor they have considered. Now, what has happened at that time, for some reason or other, the then deputy commissioner was against the petitioner, who happens to be advocate. I have to disclose that. So there was some internal clash, private clash between these two persons for one reason or other. So he was very much vindictive against the petitioner. Thereafter, what happened? Lordship, your Lordship is well aware of the act of this 2003 Act, which is similar to the Act of Central Act of 1971, which says Arunachal Pradesh Public Premises Eviction of Unauthorized Occupation Act 2000.
Similar to the Central Act, yes.
Yes.
More or less.
So what has happened, Lordship, the scheme of the Act, both the Central Act as well as the State Act is, even we have a similar act in Assam also. Now the scheme of the Act is initially a show cause notice will be given, and then the noticee will give his reply. Then the state officer has to form an opinion that he is satisfied that there has been an encroachment after considering his representation. Then the law provides that thereafter he will pass the final order of eviction. After that, Lordship, there is a provision for filing appeal before the district judge. Your Lordship is aware, your Lordship is
Yes, yes, yes.
worked in the
I
district
was dealing with
judiciary.
those
Yes,
cases.
your Lordship has dealt with such matters.
Especially the Central
Then-
Act. No, I do not know the
Ye-
state acts.
Yes, Central Act provides for appeal before the
Before the
the
district
state act
judge.
provides that appeal before the district judge.
Deputy.
And in Arunachal it is deputy commissioner. In Assam it is district judge. In Arunachal it is deputy commissioner. After that we approach the Honorable High Court. This is the provision. Now here what has happened, your Lordship, I'll take you. I'm just indicating. Initially in the year 2015. A notice was issued, and that notice, although they have mentioned section 4 of the State Act, that was not a notice to show cause as to why I should be evicted. That was a notice
Just a moment,
that
just
I
a
should-
moment, just a moment,
Madam.
just a moment.
Madam, madam.
Buni, you go and start working on it.
Section 4 now. Normal.
Yes, yes, please continue.
So what has happened, Your Lordship, in the year 2015?
Buni, 1 minute.
the-
Just a moment, give me that file. Give her that file. That half-done judgment is there. I have corrected it. Last time you have typed it, no? That half-done. You just check it. It's in the that first the petitioner's prayer. You have typed it. Or you type this. You type this. We'll worry about it later. You type this. Yes, yes.
My lord, in the year 2015, the problem started. Since the petitioner before the lordship was in occupation of a government land and he started construction, all right, the government is entitled under the law to issue notice. Now, if you issue a notice of eviction, there is a specific law, and your lordship is aware of the law, the Supreme Court judgment, relying on the Privy Council judgment that if the statute provides a particular manner, that manner has to be followed, and all other manners are excluded. Now here, what has happened, in the year 2015, they issued a notice, but that notice was not under the provisions of this act. I'll take your lordship, kindly permit me to take your lordship to page 15 once of the petition. Thereafter, I'll make my submissions, my lord. Page 15, if your lordship has got, my lord.
Page 15.
Page 15, my lord. Very unfortunate, my lord. The authority exercising power which is not provided under the Act.
Page 15, yes.
Page 15. I'm just reading few lines, my lord. In compliance of government order number so-and-so, dated 10/00/2015, the land management team of DC's office Tawang has been conducting inspection of Tawang Township every Monday and Friday. During the course of inspection, it has observed that Sri Jambe so-and-so Sharing, son of so-and-so village so-and-so Tawang, has been found constructing an RCC building near Circuit House Tawang. Whereas it has been observed by the inspection team that Sri so-and-so is illegally constructing building over government land near Circuit House Tawang without land allotment order. And whereas on being observed illegally constructing building over government land, he is directed to immediately stop the construction work. Now, therefore, I see so-and-so estate officer Tawang, empowered under section so-and-so of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2003, do hereby issue this notice giving an opportunity to produce papers, documents in claim of the state before the undersigned, or stop construction, evict the state land within 7 days from the date of issue of this notice, failing which necessary action will be initiated as per law. Lordship, this notice is not in terms of section 4 of the Act, which provides for the issuance of first notice. Assuming for the time being, my lord, for the sake of argument, that yes, it is a notice to show cause, then I am entitled to submit a reply, and they are entitled to consider my reply. What they have done, straightway thereafter, 18/6/2019, Lordship, you kindly see at page 16.
Yes. Yes.
This entire letter I am not reading, Lordship, kindly turn to page 17. The last paragraph.
Yes.
Now therefore, I see so-and-so, in charge ADC cum estate officer Tawang, empowered under section 4(1) of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003, do hereby direct you once again to remove the building materials from the government land within 7 days from the date of issue of this notice, failing which the said RCC structure will be removed, dismantled by this office, and the cost of demolition shall be recovered from you. Now, thereafter, straightway this final order comes. Then I filed an appeal under section 12 provides for appeal. page 18 is the appeal petition I have filed.
Yes.
Lordship, under the law, I am entitled to file appeal against this, and I have filed the appeal. Assuming for the time being that as against the first notice, although they said, do hereby issue notice giving you opportunity to produce papers, assuming that I have not produced papers, then they have passed this order. Thereafter, when I file this appeal, and the appeal is still today pending, and they have not taken a final call, this appeal has not been disposed of, they have now issued a fresh notice to me. Which law, under which act provides that once the proceeding is pending and the appeal has not been finally decided, they can issue a fresh notice under Section 4. Now what they have done, in between, Lordship, something more has happened. I have to indicate to your Lordship. The Deputy Commissioner, who was very much vindictive against me at that time, he has filed an FIR against me, saying that there is an order of eviction and I have not complied with the order of eviction. I have not vacated the building, so he has filed an FIR against me. Now, since FIR under the law is not maintainable there, so I have approached this honorable court by filing a criminal petition challenging praying for quashing of the entire proceeding. And there, this honorable court in the principal seat, Lordship, the matter is pending. Being satisfied with the contention raised by the petitioner, has stayed the further proceedings of the criminal proceeding. And that matter has still remained stayed. Interim order is still operating, and final hearing has not taken place till now. Now,
So investigation has been
now,
stayed.
yes,
Investigation.
proceeding, entire proceeding stage.
Entire proceeding state, okay.
Yes.
Entire
Now,
proceedings, so which
thereafter,
includes the
Lordship,
eviction process. Which includes the eviction
eviction
process.
process is not there, Your Lordship. No, it doesn't include eviction process. Does not include. It is only the criminal proceeding. It is only the criminal proceeding, and nothing to do with the eviction proceeding. Section 5 indications by having satisfaction. I need to call it. Now, Lordship, at page 20, they have issued a fresh notice. Page 20, Lordship, kindly with a very small notice, I'll just read it out for your Lordship. Page 20, my Lord. And whereas it has been brought to the notice of the undersigned that you have illegally encroached upon government land and constructed a building on the said land at New Circuit House, Tawang, and whereas survey team of Land Management Branch DLRSO's office, Tawang, has ascertained that we have constructed a building on the said piece of land without proper authority. Next paragraph, Lordship, kindly say, whereas as per case numbers, criminal petition number so-and-so, matter is sub judice and pending in the Guwahati High Court. And whereas now, again on 10/10/2023, the survey team of this office has reported that you are actively engaged in completing the illegal construction building over the said plot of land. Now, therefore, I, so-and-so Estate Officer Tawang, in exercise of powers under Section 6(1) of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003, hereby directs the so-and-so to immediately stop building construction from this public premises to avoid contempt of court order. My lord, where is the court order of eviction? I don't know. They say there will be contempt of court order. Thereafter, my lord, next page, also kindly see page 21. They have issued again a notice. It has been brought to the notice of the undersigned that you have illegally encroached upon government land, etc. And whereas notice of 11/10, the previous page which I have read, was served, has served a notice under Section 6(1) of so-and-so. And whereas you have not furnished any reply to the said notice, thereafter, now, therefore, I see so-and-so in exercise of power, again the same power, Section 6(1), same, 6(1) of the Arunachal Pradesh so-and-so, do hereby issue this notice to remove, dismantle the building on government land within 7 days from the date of issue of this notice, failing which the said property will be evicted, dismantled, and the cost of demolition shall be borne from the so-and-so petitioner, defaulter. Now, page 22, they have issued another notice. I'm sorry, I have given a reply to this letter on 4/12/2023, page 22. Thereafter, they have now Now they have issued the impugned notice again at page 24. Similar type of notice, but the language is that now they are starting with page 24, your lordship has got. Whereas notice under section 6(1) of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003 has already been served to you by notice dated so and so. Whereas this office is also in receipt of your reply by letter number so and so, when you stated that concerned encroachment matter is sub judice in the Honorable Guwahati High Court and the notice issued to you by the office of the undersigned is unwarranted. Whereas it is pertinent to mention that criminal proceedings such as FIR investigation in your matter is sub judice, but proceeding under Arunachal Pradesh so and so is a separate proceeding. Now, whereas the undersigned does not find any merit in your reply and is not satisfied in your reasons to encroach upon any government land and have given you ample opportunity to remove the structure illegally constructed upon the government land. Now, therefore, I see so and so, State Officer Tawang, in exercise of the power conferred upon me under Section 5 and Section 5(7) of the Arunachal Pradesh Public so and so Act, do hereby direct you to remove or demolish the existing structure and vacate the premises within 15 days of the receipt of the order, failing which the undersigned would carry out the eviction drive and the cost of removal demolition would be borne out by you under Section 10 of this Act. This is the position, lordship. Thereafter, I filed the representation at page 10(5)24, which is pending. And at page 29 is my application for allotment. And I have given the photographs of the structure which I have raised. Lordship, I will just read one provision from the Act of 2003. This Act provides, if your Lordship has got my learned friend assisting me there, will.
Yes.
But the Act, so Lordship may kindly have a look at Section 4. What is the procedure prescribed? Section 4 says, if the estate officer is of opinion that any person is in unauthorized occupation on any public premises and that he should be evicted, the estate officer shall issue in the manner hereinafter provided a notice in writing calling upon all persons concerned to show cause why an order of eviction should not be made. The notice shall specify the grounds, require all persons concerned, that is to say all persons who are, etc. Then, Lordship, Section 5 is the next provision. If after considering the cause shown, I have submitted my reply. If after considering the cause, if any, shown by any person in pursuance of a notice under Section 4, and any evidence produced by him in support of the same, and after person hearing, if any, given under Clause B of subsection 2 of Section 4, the estate officer is satisfied, this satisfaction is necessary, Lordship, that the public premises are in unauthorized occupation, the estate officer may make an order of eviction for reasons to be recorded therein, directing that the public premises shall be vacated on such date as may be specified in the order by all persons who may be in occupation thereof or any part thereof, and cause a copy of the order to be affixed on the outer door or some other conspicuous part of the public premises. Now, after this, Clause 2 says, if any person refuses or fails to comply with the order of eviction on or before the date specified in the said order, or within 15 days of its publication under subsection 1, whichever is later, the estate officer or any officer duly authorized by the estate officer in this behalf may evict that person from and take possession of the public premises and may for that purpose use such force as may be necessary. So this is the second, and then Section 6 is important. No person shall erect or place or raise any building or any movable or immovable structure on or fixture. B, display or spread any goods. C, keep any cattle, etc. Then 2, where any building or other immovable structure or fixture has been erected, placed, or raised on any public premises in contravention of the provisions of subsection 1, the estate officer may serve upon the person erecting such building or other structure or fixture a notice requiring him either to remove or to show cause why he shall not remove such building or other structure or feature from the public premises within such period not being less than 7 days as he may specify in the notice, and an omission or refusal of such person either to show cause or to remove such building or other structures or features from the public premises, or where the cause shown is not, in the opinion of the estate officer, sufficient, the estate officer may by order remove or cause to remove the building or other structure or feature from the public premises and recover the cost of such removal from the person aforesaid as an area of land revenue. My lord, my submission before your lordship, section 4 provides for show cause notice, 5 provides for consideration of this reply, and then form an opinion and that he is satisfied. Merely using the word "I am satisfied" is not enough. After considering the representation, and lastly, if after consideration of the representation they are not satisfied, they must come to a specific finding that these are the reasons for which we are not satisfied. Now, here in our case, my lord, I have got 2 full submissions. One, initially when they started the proceeding, I submitted a reply. Without considering my reply, they have passed a final order. After that, when I filed an appeal under section 12, that appeal is still pending. Now, if that appeal is pending, you don't take a final decision. Are you entitled to issue a fresh notice under section 4 again? Is it not amounting to undertaking a fresh exercise, which is not permitted under the law because the earlier one has not come to a logical conclusion? Once it comes to a logical conclusion, you can pass a final order. And here is a case, admittedly, my appeal under section 12 is still pending, and section 12 provides for the appeal.
See, first of all, that you submitted a reply and without considering your reply, that order was passed.
Yes.
All right. And during the pendency of the appeal, the final order was passed.
Yes, that is my view. During the pendency of the appeal, they started giving notice to me as if they are starting a proceeding afresh. Can you do it?
Okay, okay.
And secondly, my lord, the satisfaction that is required under section 5 of the Act is something where the person who is the estate officer should consider my representation and pass a reasoned order to hold that he is satisfied that you are in unauthorized occupation of government land. Lordship, as I said, I am in occupation of government land. I have raised my structure, and there is an application pending for allotment of the land. Now, on the one side, my application for allotment of land is pending, and I have alleged malafide against them because the deputy commissioner is absolutely against me. And he, under the influence of the earlier local MLA, my lord, he started the proceeding. Now, after he was transferred from my lord, Tawang, this present criminal petition pending in the Honorable Guwahati High Court, he was monitoring, he was engaging a counsel. The counsel was representing the deputy. Under what circumstances a deputy commissioner who is no longer holding the post of deputy commissioner in the district of Tawang engages a lawyer and ensures that the matter remains pending and it is pursued? Does it not show a clear case of malafide, lordship? And the criminal proceeding, the stay is operating. This Honorable Court did not vacate stay, even if they filed an application for vacating the stay. This Honorable Court was not satisfied that they have got a case, so the entire proceedings kept state. And now they have started a fresh proceeding. My submission before lordship is the fresh proceeding is absolutely without jurisdiction, because so long as the appeal remains pending, so long as the appeal is not finally disposed of, there is no question of undertaking a fresh exercise. Lordship will kindly direct the deputy, my lord, kindly direct the state respondents to satisfy your lordship as to under what law they can undertake a fresh exercise without disposing my appeal, which is still pending. So that being the position, my lord, all the notices subsequently issued are all without jurisdiction because the law doesn't provide for a fresh exercise, my lord. That is my case before lordship.
So we will
And now, my lord,
for his reply, we will commit to.
My lord, it is already. I'm sorry, my lord, it is already 1 o'clock. I did not see the clock. 1 o'clock. At 2, my lord.
No, he's placing a submission.
No.
Short submission, yes.
My submission is that, my lord, as per 2003, section 4(5) is not disputed, my lord. Now, my lord, here is the case, my lord. They have not annexed the in compliance with section 5, which is the reply to the show cause notice, although they have not annexed. Now, another thing is, my lord, they have or they adopted section 12, that is the appeal. I think that is the appeal provision.
They appeal, they have preferred an appeal.
They
Yes.
have annexed only one appeal, my lord.
There
But
has to
while
be
they
one,
were
there
preferring
can be
a-
only one.
Yeah,
appeal.
section 12. Now, against this state officer, if he passes any order, then they can apply section 12. That is the appellate authority, that is the deputy commissioner, my lord. Now, as per this record, they have filed the appeal under section 12. Now, is there any sort of interim order or not, that we don't know? Because once we file against the single bench to the division bench, until unless division bench interprets, the single bench operation, the order operates, my lord. Now here we don't know, my lord, is there any injunction order passed by the deputy commissioner section 12 or not? That we don't know, my lord. Now at this stage, lordship may issue the notice if the appeal is really pending there. Then subsequent, my lord, notice may be not legally permissible, my lord, if that appeal is
Yes,
admitted.
yes.
If not admitted, that is the question, my lord. If not, there is any injunction order.
So you get the instructions there?
Or, my lord, notice may be issued, my lord. If any appeal is really pending, my lord, then we'll come up with detail, man, we'll come up with the affidavit. my lord.
16 instruction
Because
So
it's-
he is submitting that they are not aware of any notice being
My lord.
issued against them. So should I ask for instructions?
My lord, lordship may keep it for instruction because it is necessary that what is the position, what is the status of my appeal, that instruction they have to bring. So
Now,
lordship
he
may
said
kindly.
he was fairly submitting that, yes, when appeal is pending, then
Yes.
notice cannot be issued. So he'll get the
Yes.
instructions. He's
My lord,
submitting
my lord,
fairly.
My
All
lord.
right.
My
I'll get the
only,
instructions.
only one thing, my lord, so far as construction of building, if any, my lord, I will not proceed with any construction of building because they have now issued that I should not undertake any construction. But I have undertaken, my lord, erection of retention wall. My lord, if the retention wall is not completed, entire
Yes.
house will fall. So meanwhile, only I am submitting that retention wall construction may be allowed, nothing else. Building, my lord, building of house, if any, I will not go ahead with the construction.
Yes.
my lord, only retention wall.
Retention
Only
wall, Lord
retention
Senior.
wall.
Only retention wall, my lord, yes.
Yes. Yes, I'll pass an order
Lord-
accordingly.
My lord, my lord, lordship may make it returnable by 4 weeks, my lord.
Returnable by 4 weeks.
My
We'll
lord,
issue
my lord.
notice and then meanwhile you get the instructions.
My-
Yes, yes, copies also.
My-
I'll pass an order,
The-
4 weeks.